SJC-11776, William F. Reade, Jr. v. William Francis Galvin, et al.
Good morning, Ms. Canstrom.
Good morning, Your Honors, and may it please the Court. Emily Canstrom on behalf of the appellant, Mr. William Reade. Chapter 261, Sections 27A through G, governs requests by litigants for the waiver of certain fees and costs associated with filing litigation. It is designed to provide access to the court system for certain categories of people whom the legislature has deemed indigent. One such category is people receiving public assistance in the form of veterans' benefits.
Do we know, I mean, you'll acknowledge that if you look at the statute as a whole, to the extent we're not talking about needs-based veterans' benefits, that it sort of stands out like a sore thumb? I mean, is there anything in the legislative history that suggests that it doesn't matter what kinds of veterans' benefits you get, doesn't have to be needs-based, we just want to do this for our veterans? They could be, because there are lots of reasons you can get veterans' benefits. You could be a millionaire who's lost part of a hand in combat, for example. So could you speak to that? I mean, what is it that would take this and make us think that the legislature really meant this for all veterans' benefits?
Certainly, Your Honor, and I agree that there are a wide variety of veterans' benefits available both at the state and federal levels. The legislative history doesn't bear directly on the question of how the phrase veterans' benefits should be interpreted. That said, at one point the statute contained the modifier Massachusetts before that program, and that was removed, broadening the term, if anything.
When Massachusetts, because somebody makes the argument that Massachusetts veterans' benefits were needs-based as opposed to the universe. When the word was removed, was there any legislative history with respect to that particular action?
None that I'm aware of, Justice Botsford. That said, there are benefits even in Massachusetts that are not necessarily needs-based. They may be based on a particular disability, they may be service-based. And if I'm assuming that we mean when we're using the term needs-based, I'm assuming that we mean based on one's financial means, because I would also take the position that there are means-tested benefits that might be based on disability. And to Justice Lang's point, in Massachusetts, as far back really as the 18th century and the French and Indian War, we have provided special benefits to our veterans, and the argument would be that's exactly what's happening here. There's no limitation in the statute on this language, and the legislature is presumed to understand the consequences of its actions and therefore presumably to be aware of the breadth of that particular term.
The term public assistance, is that used elsewhere in statutes? Does it have a meaning? We generally don't refer, say, to a veteran receiving retirement benefits as receiving public assistance. They would be offended to have that term attached to it. What meaning should we give to that term?
The term public assistance is not on its face limited only to financial assistance, and in fact, if one looks even to the dictionary definition of public assistance, it does also include disability benefits. And in this particular case, Mr. Reade is receiving benefits based on his service and his disability, namely in the form of a property tax exemption, which is a Massachusetts benefit accorded to veterans who have at least a 10% disability and satisfy other continuous residency requirements in Massachusetts. Furthermore, Your Honor, if the legislature meant only veterans who satisfied the poverty threshold, that is to say 125% or less of the poverty threshold as set forth in Category B of the statute, the legislature really had no need to add this particular category for veterans. In other words, if we're talking about people who were poor by definition under the statute and also happen to be veterans, they're already encompassed in the statute.
So if, just to go back to your previous point, if the person were a firefighter who got pushed up on the list because of prior service as a veteran, would that be public assistance for purposes of this statute?
I'm not sure I understand Your Honor's question.
A person took the civil service exam to become a firefighter, scored 100th on the exam, but by virtue of having been a veteran, was pushed up considerably higher on the exam, and the benefit was it got this person the position of firefighter that he or she otherwise wouldn't have qualified for. Is that person indigent within the meaning of the statute?
Based on the plain language of the statute, yes. If it is a veteran's benefit that is accorded to a veteran, based on the fact that that person is a veteran, yes, that person would fall within this statute.
Do you really need to go that far, though? I mean, I thought here we're talking about he gets a monthly payment from the Veterans Administration, right?
Yes.
And a partial abatement on his property tax. We don't need to go to, did he receive a veteran's preference in some civil service context to make your argument, do you?
No, not in this case, Your Honor. In fact, as I said, Mr. Reade is receiving the types of veterans' benefits that Your Honor just listed. And I think Your Honor also gets to another point regarding veterans' benefits, which is that this is a complicated scheme with various benefits peppered throughout both state and federal laws. So to the extent the court were looking to read any sort of limitation into this particular term, I think the court would have to be very clear about what that limitation would be, particularly so as to provide appropriate guidance to the clerks and trial-level courts who are going to be dealing with this.
What if that limitation were need-based veterans benefits, whether they be federal or state?
I don't think that would be enough, Your Honor. Having spent some time looking at these types of benefits, it would not be immediately clear to me, and I'm certainly not an expert in this area, but it would not be immediately clear to me which benefits fall in and which benefits fall out of the phrase needs-based. For example, there are education benefits available to veterans. There are annuities that are given to veterans. There are education benefits. There are all.
Well, I take it means that it's you get them based on your income at the time, would be probably how it's done.
But education benefits aren't dependent on income, are they?
No, not to my knowledge, they're not. But I think the question would be, if we're saying needs-based, would that encompass things based, for example, on disability? Would it encompass limitations on how long one served or in what capacity one served? If we're just talking about financial means, then again, certainly the statute could be limited that way, but the fact is that it wasn't.
Right.
And the legislature could have, but didn't.
Could I ask you this? Under 27C6, do you think that your client here, that if we accept your argument that the veterans' benefits qualify him to be, quote, indigent for C1 purposes, but under 6, somebody could make a determination that all but $1, presumably, he is able to pay, and so his indigency benefits would be basically de minimis. Would that be appropriate reading of 6?
That would be an appropriate reading of 6, but it wouldn't be an appropriate reading in this case, respectfully, Your Honor, because Mr. Reade elected subsection A, noting that he's indigent based on his receipt of veterans' benefits, there should have been no inquiry into his finances at all.
Well, that's another one of your arguments, but let's just assume for the second, I'll go back there, but just assume for the minute that that were not the case. Would it be appropriate under 6 to get at the to get at means-based, I mean, essentially?
The question being, could the court examine his finances?
Exactly. And if it found that, in fact, he's not means-based indigent, that it could assess costs up to, because the statute says reasonably pay part of the normal fees, up to $1. I mean, up to $1 left.
No, Your Honor, I don't think that would be appropriate in this case or in any case in which a litigant is electing veterans' benefits as the reason for which he or she is receiving them, because the point of having these proxy categories, these categories of categorical or automatic eligibility, is exactly that the court would not be looking deeply into one's finances.
Well, but subsection 6 doesn't say anything about its only category something else other than, right?
No, I think that's right. Subsection 6 does not say that it's limited to the other particular categories, but my argument would be that the statute taken as a whole implies different types of inquiries for the different subcategories included in subsection A. And had the legislature not wanted to have these categories of automatic eligibility, the statute could have remained as it was originally drafted in 1974, at which point it had only a large discretionary category that mimics what we now have as subsection C. And we could have left all this discretion to the court. It would have been a searching and deep inquiry. It also would not have been as efficient or streamlined, and arguably not nearly as uniform as the statute now seeks to make it.
Why is it totally irrelevant that Mr. Reade was not deemed indigent under either of the first two categories? The court is aware that he's not indigent, and the court is also aware that the purpose of the statute is to allow for payment of costs for people who are indigent. So I don't understand why you think we should overlook the fact that he really isn't indigent.
Well, first, Your Honor, I would respectfully disagree with the fact that he isn't indigent. The statute defines the term indigent to include veterans' benefits, which, as Justice Cordy pointed out...
Well, that's your argument, that that's what it does. It's not entirely clear that it does. Well, we do know that he's not indigent under either one of the other two categories, though. Would you agree to that?
I would agree, and neither of those affidavits are up on appeal at this point. Really, the only one that we're looking at now is under subsection
I understand, but they're part of the record, and
Yes,
it's
Your Honor.
part of what the judge considered.
Yes, Your Honor, but the statute, particularly under 27C3, instructs the judge, if the judge has a serious question as to indigency as defined in Section 27A. And here the court had no serious question as to the basis on which Mr. Reade elected his indigency, namely that he was receiving veterans' benefits. To the contrary, the court explicitly found that Mr. Reade was, as a factual matter, receiving those appropriate benefits.
I know the judge found that he was receiving veterans' benefits, but the judge did not find that he was receiving benefits based on need. That's two different things.
I agree with that, Your Honor, and my interpretation of the statute and the argument here is that the judge did not need to find that he was receiving benefits based on need because the term veterans' benefits isn't so limited in subsection A. And I would also point out that if the court, if the judge were to be entitled to look into the record, into filings and other documents extraneous to the grounds on which the litigant has elected indigency, here, veterans' benefits, again, there's no point in having these separate categories that the legislature added in 1980. Or we could just have subcategory B if the litigant is at 125% or less of the poverty threshold. Or we could have a broad discretionary subcategory C. But by adding subsection A and providing these specific special categories, the legislature must have meant something and must have meant to impose some sort of limit and to streamline.
Didn't they mean something in considering context of what those other programs are?
I'm sorry, Your Honor?
Don't you consider the receives public assistance and then all of the categories of assistance that are listed in A? That's part of it, right?
That could be part of it.
Shouldn't it be?
No.
Isn't it always in statutory construction? That you consider all of the list, the items in a list?
Yes, but the primary principle of statutory construction, respectfully, is that where the language of a statute is plain, the function of the courts is to enforce it according to its terms.
This is part of a list, and you can't take it out of the list. It's only plain if considered in the list.
I would argue
Agree with that principle?
I definitely agree with that principle as a general matter, Your Honor. But in this particular case, the phrase veterans' benefits connotes a broad interpretation, which is something, as I said earlier, this state has always done. We've provided special categories of benefits to our veterans, and because the legislature is presumed to understand what it's doing when it legislates and to act rationally and reasonably, in this particular circumstance, the conclusion is that the legislature understood that by not limiting the term, certainly the legislature could have inserted another definition section into 27A and said veterans' benefits means the following programs. That doesn't exist here.
Well, they could have, I mean, you don't just look at the word in isolation. You look at the word in the context of the purpose of the statute. And the purpose of the statute is not a veteran's preference statute. The purpose of the statute is to allow people, poor people, to have access to the courts. This is not a veteran's preference statute.
I agree with Your Honor that it's not at its core a veteran's preference statute. I would say that the purpose of the statute is a little bit larger. It's about access to the court system, it's about efficiency, and it's about uniformity.
You're saying that that's what happened when the legislature removed Massachusetts from the list when it changed the statute in 2000? But it wasn't about extending veterans' benefits, right? Wasn't it completely benign, and it was an act making certain corrective changes? It wasn't an act to expand benefits for those who have the status of veterans.
Even prior to 2000, when the term Massachusetts was removed from the statute, the phrase veterans' benefits was still in the statute, and it still didn't have any modifier, such as needs-based or any other limitations
Except for
on it.
Massachusetts.
Except for Massachusetts.
This only allowed it to go beyond Massachusetts.
Yes, Your Honor.
Okay.
Are there any other, in the other items listed in that same section, listing these other categorical definitions of recipients of benefits, is any other kind of benefit at all financially means-based or not financially means-based?
My understanding of the other benefits is that they all have some financial component, although they may also have, in addition to that, other components like disability. I see that my time is almost up, Your Honors, and before I rest, I would just want to point out to the court that if the court is inclined to impose any sort of limitations on the term veterans' benefits, this case would need to be remanded for factual findings as to whether my client then receives the appropriate benefits that would qualify him under this statute.
Can I ask you one question? Just a follow-up question. Title 16 of the Social Security Act, is that the disability provisions in the Social Security Act?
I believe that's SSI, Your Honor, which includes, to my understanding, both needs-based and a disability component.
Both, so you would have to meet both components in order to
That's my
get
understanding of
benefits
that
in.
provision, yes,
Old
Your
age,
Honor.
disability, all needs-based, though.
Right.
Right.
Thank you.
Thank you.
Thank you, Your Honors.
May it please the Court, Daniel Sullivan, appearing this morning as a Special Assistant Attorney General representing the Intervenor Office of Court Management. And I'm pleased to have with me this morning my colleague Gwen Werner, who's the Deputy General Counsel of the trial court. Your Honors, when the plaintiff appellant, Mr. Reade, applied to the Superior Court for the third time to be treated as indigent, he had sworn in a supplemental affidavit just 6.5 weeks earlier that he had not only significant income, but also even more significant equity in his home. And I won't cite those exact figures because this is confidential, but they appear in the record in the supplemental appendix at page 39, Judge Rufo's
So
February
the
14th.
question, so the issue is whether it matters at all.
Yeah, it's that he would argue that's irrelevant.
I respectfully submit that it's not. I think that the first thing I want to talk about is was raised during my sister's argument, Section 11776, and I want to point out to the Court that that amendment was added by Chapter 68 of the Acts of 2011, so it's the most recent utterance by the legislature on this statute. And the language reads, if the court makes a finding that the applicant could reasonably pay part of normal fees and costs or extra fees and costs, the court may assess a reasonable partial payment towards said fees and costs.
So in other words, no matter what category of indigent you fit under, the court can, and maybe should, make an inquiry as to whether, notwithstanding those benefits, they could pay part of the normal fees?
That's correct.
So it doesn't matter. So they could be on aid to families with dependent children. The court could still make inquiry. Well, okay, you are, but let's look at some other assets you might have. So the court could do that.
Well, I think the court would know this such an inquiry was unlikely to be fruitful, given the fact that AFDC has strict eligibility guidelines.
Well,
But isn't there a fork in the road here? As I look at subpart 2, it says that if the affidavit appears regular and complete on its face, if somebody showed up, filled out an affidavit saying, I receive veterans benefits, if we didn't have the slightly complicated history here, if an affidavit were presented for the first time that the person received benefits, the statute seems to say that the clerk shall grant the request forthwith without a hearing, and it's only if there are some ambiguities that the decision then goes down the other fork and goes to a judge where sections 4 and section 6 then apply. Or am I wrong?
Well, Your Honor, the affidavit has to appear regular and complete upon its face. So in this case, it certainly didn't. We had these...
Well, it also has to only, at least as I read too, one could argue that it also has to only be seeking normal fees and costs.
That's right. Those are the three
not
standards.
extra
It has
fees
to
and
appear to
costs.
meet the definition.
But take that as a given, and I think Justice Fina's question remains, which is that suppose that we didn't have this history, simply said recipient of veterans benefits to begin with, never had the other affidavits, only sought, the normal court costs. So you don't have anything else. Isn't there a fork in the road that says the clerk does not then give it a hearing? Doesn't, that's it.
If there
never get to your 27C6.
If there had been no other way in which it was irregular, Your Honor, and it didn't satisfy Section 2, I believe that the clerk would have no reason to refer it to a judge.
But then how would you ever get to C6?
Well,
27C6?
Well, in many cases, there will be something irregular in the affidavit, or the plaintiff will have asked for extra fees and costs.
All right, but would you agree that theoretically, if this meets it fits squarely within 2, that you never get to 6 because there is this fork in the road?
Respectfully, Your Honor, my argument there is that this court should not read veterans benefits programs to be anything other than needs-based.
I know that. I'm just trying to get hypothetically whether you agree with the fact that there is a fork in the road.
There is a fork in the road. If the affidavit were regularly complete upon its face, the individual only asserted the receipt of veterans benefits, I wouldn't think the clerk would have any reason not to approve it summarily.
Let's assume you get what you want, which is that this is interpreted to be only need-based. Ms. Canstrom says there's no list of need-based federal or state programs, and you haven't provided us with one. What's a clerk supposed to do?
Well, I think that the inquiry should be made as to whether or not the veterans benefit asserted is indeed a needs-based veterans benefit. In this case, we had, first of all, the plaintiff's benefit here is a property tax exemption. Well, the state veterans benefits are generally governed by Chapter 115 of the general laws. This is a property tax exemption. It's not clear to me that it's what really is intended as a veterans benefit program.
I thought he also got a monthly disability payment.
He does get a disability from the federal government. That's accurate. But the difficulty again, and the federal benefits is even more pronounced, is that many of I have a list of 12 pages of federal veterans benefits. Many of those benefits, if not most of them, are not needs-based. Right. Veterans have all kinds. Any veteran has many rights.
I mean, I'm a clerk in Suffolk, and somebody walks in and says they're a veteran. How am I supposed to know whether it's need-based or not unless there is a list of need-based programs which we can say is what this term means?
Well, at a minimum, I would ask that the affiant assert that the benefit he receives is needs-based.
How in this, going back a step, is there anything, when veterans benefits was added in 1980 to the statute, was there anything to suggest that these kinds of limitations was what was meant?
I've examined that statutory history, Your Honor, and there's this bill passed through immediately before prorogation, at the very end of a session, with 5 or 6 other bills, and as far as the State House News reflects, there was no discussion of it. So it doesn't seem to me that if the court intended to create a veterans benefit here, that there wouldn't have been some statement during the course of the session that we want to add this because we want to honor our veterans.
But if you don't, if you add it as a categorical qualification for for indigency with nothing else attached to it. Why isn't Ms. Canstrom right that it, we're honoring our veterans? That's what we're doing. And we know that it isn't needs-based, but we want them to be treated as, quote, indigent for purposes of court costs.
Well, Your Honor, I refer the court to Hanlon versus Collins, that a statute must be interpreted from all its words, considered in connection with the cause of the enactment, the mischief or imperfection to be remedied, and the main object to be accomplished. The mischief to be remedied here is the denial of access to justice to potential litigants who cannot afford to seek it without assistance.
Are there statutes where veterans are simply given, a special status that have nothing to do with the overall, or nothing as self-evident about why veterans would be given a special status?
Well, in the context of this statute,
No, I mean in the context of other statutes. I mean, it's not unusual for veterans to be given special
Like veterans' preference for civil service.
And that the point of civil service legislation is not a veteran's preference.
Well, but that's a good question. Is that a veterans benefit program, a preference for a civil service veteran? Would someone who receives...
If it didn't mean something like that.
Well, it would mean programs, and there are such programs, and particularly under Chapter 115 of the general laws, there are programs, any of them, that are needs-based.
Well, but we don't have a list of them. You're saying we can find all that information out by just looking at the statute, 115? That'll tell us everything we need to know what a needs-based
I'll acknowledge it's a complicated structure, Your Honor, and it may be that further findings are needed on that, or supplemental submissions could be made to this court.
Yeah, but that's a problem, because you're saying the legislature couldn't have been so foolish to have made all veterans who are receiving benefits indigent, and your argument is the legislature was so foolish as to create a need-based criteria, and you have no clue what that would mean in practice.
I took the record as I found it, frankly, Your Honor, but I don't. I think that seems to me that those matters would have to be entered as evidence below.
I mean, the problem is if you asked us to basically say interpret this to be need-based, but the whole theory of subsection A is that the clerk can piggyback on the executive finding that this person is indigent. And we're not, if AFDC says they're indigent, then we will treat them as indigent. That's the theory of subsection A. That's why you don't need any further findings. We will piggyback off of the finding of the executive office, which made that determination. But I don't know how you piggyback off of the veterans' findings need-based unless you know which programs are need-based, and you haven't given us a list to attach to a decision which would find in your favor.
It would have to be a very exhaustive list, Your Honor. I mean, I can cite examples of such non-needs-based benefits.
No, I'm referring to needs-based. I'm thinking of the clerk. The clerk basically, you say we should interpret it to be veterans' benefits that are need-based. And I'm thinking, okay, if we say that, then a clerk can say, okay, well, tell us which ones are need-based so that we can allow the application when we see those. Well, and you're saying, well, that's actually really hard to do.
Well, Chapter 115 of the general laws contains an indigency requirement. I would think that veterans benefit programs that were being referred to when the legislature adopted this statute and referred to Massachusetts veterans benefit programs are those programs. And by the way, Is that
the only statute that deals with veterans program, Massachusetts statute that deals with veterans programs?
What I would describe as veterans programs, this one, as I say, is a property tax exemption, which I would not describe as veterans benefit
but I mean,
program.
but
Yes,
that's the only one.
That is the chapter on
That's the
veterans
only one.
benefits. Yes, Your Honor.
If you're right about subsection 2 and that a presentation to the clerk gets a buy on the question of normal fees and costs, and a presentation with respect to extra fees and costs has to be presented to a judge, then at that point, don't the other sections kick in, sections 4 and 6, and a judge does have some discretion with respect to extra fees and costs to make to look into the person's ability to pay?
I would agree with that, Your Honor, and I think that one of the puzzling things to me, and I want to refer to the Roe versus Rosencrantz case, one of the puzzling notions here to me is that a judge in trying to determine the truth would be restrained from looking at prior filings. I can't think of another situation in which a judge engaged in trying to determine the truth is restrained from looking at such filings.
But do you agree that if somebody presents an affidavit indicating that he or she is a veteran, they at least get a waiver of normal fees and costs under subpart 2?
He wouldn't.
I'd say the court has discretion. Once the matter is referred to a judge, under the language of the statute, the court has discretion, first of all, to determine whether or not to hold a hearing, and then secondly, based upon that hearing, to determine whether or not there's a serious question as to indigency. The statute does not limit that discretion based on the ground on which the matter was referred to the judge.
No, but I may beg to differ with you, because I think it says indigency as defined in 27C paren A, which gets you right back to veterans' benefits.
It reads...
Doesn't it? 27C3?
C2?
C2.
No, I was talking about when it gets to the judge. Is that 4, 3?
It's 3.
3. Isn't there a reference to 27 as defined in?
Yes.
Right, but it doesn't limit it as to what that is to say, the 6 doesn't limit the 3, I should say, doesn't limit the judge's ability to look at the entire record. That would be my position, Your Honor.
But 2 does, if he's only making a presentation for normal fees and costs. The clerk.
Right, that would be the situation we described earlier, where if the statute had nothing other than if it appeared to reflect indigence, and if it only asked for normal fees and costs, then it would not be referred to the judge.
Well, separating normal fees and costs for the additional extra fees and costs that were requested here, I take it you would say that whenever extra fees and costs are requested, surely the matter can be referred to the court, to the judge, for a hearing, correct? No matter what. Would you say that's true? When extra fees and costs are requested, it doesn't matter whether on the face of it the individual receives some public assistance program as defined in indigency. The matter can be referred to the judge to make further inquiry.
As I understand it, it should be referred to the judge.
And just because the person, maybe I'm wrong about this, just because the person otherwise qualifies as indigent under the definition, the court still doesn't have to grant extra fees and costs, right?
That's right.
Okay.
That inquiry is essentially unlimited, where the judge determines whether there's a serious question as to indigency. That's really a matter of judicial discretion. And if the judge does determine that there's a serious question, then the rest of Section 3 is triggered, which requires the judge to look at all manner of financial and personal information about the applicant.
But if we don't agree with you that veterans' benefits are not a categorical definition of indigency, then when the judge has a hearing, and it says if it appears at the hearing that there's a serious question as to the affiant's indigency, as defined in Section 27A, then before making a finding of indigency, the court can consider these following facts. But if that being a recipient of the veteran's benefits is itself enough under 27A to warrant a finding of indigency, does the judge go any further than that? I mean, we either accept your view that somehow it has to be needs-based veterans' benefits, but if we don't agree with that, then does the judge go any further than to find that this is a recipient of veterans' benefits, that's an indigent person as defined under the statute, and it doesn't matter, nothing else matters?
It seems to me you could get down to 6, though, and then it would matter.
And the question is if it does.
That's it. I mean, it seems to me that 6 is unrestrained. It doesn't matter how the person's qualified, whether he's qualified because he received AFDC or whether he's qualified because he's a veteran. The judge can look at his record and say, look, I think this individual can afford to pay part of the fees and costs. And by the way, there's no reason if that's true, if someone has to pay partial fees and costs who can afford to, I don't understand why someone who can afford to pay all his fees and costs couldn't be required to, even if he meets one of the other criteria. It seems to me that that later added section was the legislature's attempt to say, wait a minute here, we don't want people having their fees and costs paid when they can well afford to pay them. We want them to pay, even if they can only afford to pay part. And I would read that to mean that even if they can afford to pay all their fees and costs, that they certainly should be required. We're dealing with a limited resource. The judge's role here is to try to prevent the misuse of the trial court funds to pay for the litigation of someone who can well afford to pay for it on its own.
So if someone asks for extra fees and costs, it goes over, it leaps over subsection 2. And under subsection 6, it seems to be saying that the judge can revisit even the question of normal fees and costs, as well as extra fees and costs.
I believe that's correct, Your Honor. It seems to me that subsection 6 is comprehensive, that it contemplates, irrespective of how the person qualified initially to be treated as indigent, it allows the court to look at the question of whether or not he can afford to pay. And, you know, counsel cites the fact that these the categorical listing is meant to streamline the process, and I understand that. That makes sense. But I think that the Veterans Benefit Program piece is an outlier, and I'd refer to the court to the rule of statutory construction, that a word may be understood by the company it keeps. I've got the phrase here, nostatur et socis, that in a list of all income eligibility qualifications, that there's every reason to believe that that was what was intended when veterans benefits programs were included there, particularly because the vast majority of Massachusetts veterans benefits programs, or at that time it may well have been exclusively, were all needs-based. I think when the law was adopted, I'm not sure the court had any reason to believe there was any non-needs-based Massachusetts benefit program that might be asserted as a basis for claiming indigence. And I further wanted to say that it doesn't make sense to me that the legislature, if it wanted to give the benefit to these veterans, rather than creating a separate subsection and saying, irrespective of income, anyone recipient of veterans benefits shall be entitled to a waiver of fees and costs. Instead, why would the legislature create this fiction, this elaborate fiction, that, well, we know that this veteran's not really indigent, but we're going to ask him to assert his indigence based on the fact that he receives a non-needs-based veterans benefit. It seems to me that makes very little sense. If the legislature is generally very excited about the opportunity to do something acknowledging and recognizing veterans service. In this case, that's not what they were doing. They were trying to identify veterans benefit programs as showing financial need, because at that time, veterans benefits programs almost, I think it may have been exclusively, don't want to go that far, but I think almost exclusively, at any rate, were needs-based programs.
At what time?
In 1980, when the statute was adopted.
Not when it was amended to take Massachusetts out?
No, that amendment was, as was pointed out, that amendment was a corrective amendment, 60-page bill of corrective changes. There's no reason to believe that that was intended to be a substantive amendment.
All right, thank you.
Thank you, Your Honor.
We'll take our break.